Thank you. Let's hear from Professor Anderson.
Ya Palingina, Pankana Ian Anderson, Palawa Trawana, Trawalawe, Parabana Plamamarala, Katumiri Mani Nano Tiana, Kanamina Nena Nika Lanena. Hello, I'm Ian Anderson. I'm Deputy Vice Chancellor of Students and University Experience at the Australian National University. I'm very sorry I'm unable to join you in person today. The Centre for Native Title Anthropology conference theme for this year is Protection and Management of the Indigenous Estate under Native Title. It is an expansive theme and it covers issues of concern which have arisen over the past 12 months in cultural heritage protection, brought to the front of mind by the Yukon Gorge destruction and the expectations of resource industries, but covering the enduring challenges with disputation and the scope to achieve successful community development, to name some of the key challenges in anthropological practice in native title environment. This is the first time that the Centre has held a national annual conference via Zoom. COVID is demanding that we explore new ways to support the community of practice, and as with education in the tertiary sector, adaptive, flexible approaches are essential. CNTA is celebrating a number of firsts with this year's conference. The active role of native title representation bodies, native title service providers and land councils played in shaping conference content with an emphasis on practice challenges and questions arising from their work with native title claimants and native title holders. A further first this year is the appointment of co-director Ms. Petronella Vazon-Morel. Her appointment acknowledges her experience and expertise in native title and associated anthropological practice. I'd like to pass on my personal congratulations. So recognising the position of women anthropologists in working in native title, her appointment will contribute to the expertise of CNTA and can offer when shaping workshop research agendas and so forth. I wish you all the best and hope you have a productive discussion. Walika, and thank you.
Hello and welcome. It's a great pleasure for me to introduce the co-director of the ANU Centre for Native Title Anthropology, Emeritus Professor David Trigger. As many of you will know, David's research focuses on the different meanings attributed to land and nature across diverse sectors of society and in different countries. In Australian Aboriginal studies, he has carried out more than 35 years of anthropological study on Indigenous systems of land tenure, including applied research on native title claims and resource development negotiations. So I'll now hand you over to Emeritus Professor David Trigger for his keynote, Protection and Management of the Indigenous Estate, the Role of Professional Independence in Anthropological Studies of Native Title and Cultural Heritage. Thank you.
Thanks, Petronella, and thanks everybody for joining for the conference. I'm going to speak using some slides shortly because I think I've found from video conferences it's useful for something to look at. My remarks today are chosen from a very wide range of issues that I think surround the practice of anthropology in this sector. What I want to focus on today is a sort of a somewhat vexed question that I think many of us experience over the years about independence, professional independence of working as an anthropologist, whether or not people are employed as in NTRBs or other organisations, or whether they're operating as consultants in settings which can be political, highly political, and where expectations from different parties can desire outcomes that suit their interests or their clients' interests. So the question is, I think, for many of us, what are the expectations? What are the understandings? What are the expectations of the understandings and the professional role that anthropology brings? I'll just share my screen now. And hopefully that you can see the screen quite okay. Well, I think we know that anthropology has credibility and legal standing in the sector. Just a few points there stating the obvious, that it's been 50 years since Professors Berndt and Stanner first gave expert evidence in the Gove case in Northeast Arnhem Land. 45 years since the Northern Territory land claims began, 30 years since Native Title Act and other legislation around the same time, such as the Queensland Aboriginal Land Act, which similarly involved preparation of lengthy reports and expert testimony from anthropologists. And of course, cultural heritage laws in all jurisdictions across the continent. The bottom point is that in all of this, the work is framed largely by legal procedures. And I think that is a fundamental issue for the practice of applied anthropology in the sector, and can lead or encompass some of the tensions that I want to speak about. So I think, again, as so many who've joined us today will know, the expectations include independence of practice and expertise by anthropologists. But many of the settings in which the independent inquiries occur are also ones with other professionals, particularly lawyers, operating with commitment to the interests of particular parties and particularly Indigenous parties. And there is, I think, potential for some lack of clarity or tension to arise at times between the expectation for independence of inquiry on the part of anthropologists, and yet forms of commitment to the interests, particularly of Indigenous parties, sometimes other parties as well. And I've noted their ethics rules just because it's a microcosm of this tension, where in certainly universities and the Canberra IATSIS organisation, any inquiries with Indigenous collaborators and interlocutors is expected these days to right up front answer the question about how those inquiries will be run in order to benefit those who participate in the research, if you like, or in the inquiries. So you can see, as arose with the most recent revisions of IATSIS's ethics rules, this can provide some tension with expectations in the legal arena that anthropologists work without knowing the answers in advance of carrying out their inquiries. And of course, the outcomes may or may not meet the kinds of ethics expectations. So I think that's an interesting issue for discussion. Just going down those dot points, again, all people here know the wide range of tasks across land councils, NTRBs, in government, private sector and consultancies. There's a very broad range of tasks. through mediation and litigation, involving sometimes lengthy work on reports. And most importantly, in that second dot point there, the work of the anthropologist is subject to legal scrutiny. And it's just to make the point that for those of us who've gone into this area for some time now, this is very different from the expectations and reception of anthropological work in the academy and in other relevant research organisations. The legal scrutiny and the legal context is tremendously important, I think, in framing the expectations about what anthropology will do. And the bottom dot point just takes us to the input that is sought. Anthropologists are not just working on native title claims, they're working on post-claim determination development issues, the decisions that are made by native title holders about management of their country, and of course the distributions of money and other compensation benefits. So these are not small issues that anthropologists are increasingly being thrust into. And I think then some relationship or tension between what we might call administrative work on the one hand and professional analysis on the other, both simultaneously, potentially expectations. By administrative work, I mean work which is tremendously important in terms of responding to native title holder assertions of their interests, inquiries by phone, email, in meetings, the work of not necessarily going in and performing new studies or new analysis, but the management of the legally recognised rights or the rights which are seeking to be recognised. And the second dot point there points to the vigorous communications and to the politics among Indigenous parties, which anthropologists and other colleagues, such as in community development and so on, and for that matter, lawyers will encounter. But in terms of anthropological contributions, these vigorous communications can be asking the messenger, if you like, to restate and reinterpret what the implications of the legal findings are as to people being able to pursue their interests. Through all of this, then, there's this expectation to maintain professional independence and to stay true to the facts as have been established through legal processes, and yet an expectation, particularly I think for anthropologists working for and with Indigenous parties, that there is a broad arena of support, clearly, for the interests of those clients. So the professional role at the bottom there and how to respect it can be difficult. And in native title and cultural heritage, there can be very high stakes in terms of money. Other people have written well about cultural heritage, for example, and native title is not just about culture. It's about an economy. So there is a heritage economy, for example, which operates and swirls around the work that anthropologists do, trying to address customary concerns about about modification of landscapes and sites and whether that's acceptable according to traditional law and custom. And yet I've also inserted in that second dot point that I think it's more so than other professionals, other workers, or at least very much the case that anthropologists will also be aware of strategies of traditionalism, which can be commensurate with customary concerns or intention with them when decisions are being made and recorded and consultations occurring about the high stakes outcomes of proposals for development on lands where there are legally recognised native title rights. And the third dot point there just takes us to, you know, a distinction which was introduced a long time ago, actually, I think arising in Central Australia initially, that is, that there's work that anthropologists can do that isn't really research, or at least it is about clearance, about eliciting decisions whereby a project, a particular project or development is cleared without going to cultural details. And I want to come back to that. But if the anthropologist is facilitating yes or no decisions about the management of country, how does that sit with the idea of analysing the question of who are the right people and what's the customary basis for those decisions? The issues don't end with the legal determination. They're all about the management of rights in those ways. And of course, some will raise the question then, when and where is anthropological expertise needed? The same will be said about archaeology and some other expertise, particularly in the cultural heritage sector, which is so big now across all jurisdictions. The Minister for Indigenous Affairs in Western Australia, Ben Wyatt, himself an Aboriginal man, through the discussions about the new legislation which has now come to be passed, raised the question, well, you know, heritage, why do we need anthropologists or archaeologists or any other professionals? We just need somebody to go out there with a clipboard and record what the decision is as to whether a proposal is allowable according to traditional law. Well, that's a big conversation, as everybody in this conference would know. And the answers to it is some of what I'm trying to get at here. So the question becomes, you know, well, is an understanding of cultural connection always required? Nevertheless, when the anthropologist goes in to record a yes-no decision or to document or update the list of people who are the appropriate ones for making these decisions or receiving potential benefits from them. And down the bottom there, I'm just taking us to some of the contested matters that professionals among heritage practitioners certainly debate, which is whether or not there's a role for the practitioner, the anthropologist in this case, to assess the level of cultural significance rather than just document all places where there is some customary connection to country. The tensions that can arise between archaeological deposits and of material domains and small artifact scatters, for example, on the one hand, as against sites of major spiritual significance. Another area is the anthropologist being aware through previous literature of the way in which views may have changed over some decades as to greater or lesser significance, let's say, of small artifact scatters. And cartographic and social boundaries are absolutely critical for anybody who actually works at the coalface in this area. And of course, this is a difficult question for cross-cultural translation. We have you might recall the classic discussions about anthropologists being cross-examined as to how wide is a dreaming track, because that's been very necessary, if you like, in terms of establishing the boundaries of an allowable development on Indigenous lands, but not something that's easy to address in traditional law. So to move fairly quickly through this, you know, the question is there always an investigative role rather than just an administrative role for the anthropologist? How much ethnography is needed, if any, in some tasks that are being carried out? Will PBCs or other organisations simply produce lists of relevant persons, you know, the land councils and the NTRBs and the PBCs? Does the anthropologist just go in with that list of persons, accept that they're the right people, not exercise any professional judgment about that, despite what the anthropologist may encounter, if you like, in the field or in meeting contexts or whatever? Will the anthropologist put to one side any knowledge of what previous studies have been? How much will those previous studies need to be addressed? And particularly in the bottom dot point there, what about conflicts of interest among those consulted? I think there's an assumption that can operate that anybody who says anything about customary connections or the acceptability or otherwise of developments and the management of rights is presenting information that will simply be recorded by the anthropologist and taken back and inserted into the archive. But the anthropologist will know about potential other interests driving the positions that people may take. Different Indigenous parties within the jural public, the relevant jural public. The question is how much ethnography and analysis is to be done. So I've raised that first point about whether we're relying on a list. The question of Indigenous politics, which can't be dodged in many cases. The fact that the legal process tends, I think, too often to have a disinclination to address those conflicts using the notion that they're intramural, and we can discuss that, and the question of whether lawyers and others' understanding of what's involved for anthropologists is understood. There are big questions about change, which I think I'd be interested to hear what other people have in mind. But I think this matter is yet to be faced over the coming couple of decades. Will the legalities of outcomes continue to define the range of rights holders and the definition of their rights and interests? Or will change across the relevant jural public mean that there will be asserted a right to change those rules, to change those laws and customs? And if so, how and to what extent? You know, intergenerational changing knowledge, intergenerational differences about the definition of who are primary rights holders and so on is around across the sector. So I think we need some local level expectations for what it is that anthropologists do. Whose role is it to set those expectations up or to advise parties on what they are? We need some expectations about how anthropologists will deal with challenges and disagreements and disputes about their expertise, about how organisations and consultants will deal with blaming the messenger. And in the bottom dot point there about the well-being and safety in the workplace, which includes not just the office, but the field settings as well for those anthropologists. And I just want to spend a few minutes linking to a relevant issue arising, going back to the legal system and the extent to which it's open to these anthropological concepts and findings that might complicate what are otherwise regarded as settled legal matters. Complications introduced from anthropological practice. I want to say it's commonly not a collegial discussion. Anybody giving evidence in a court or in a mediation setting, in my view, needs to know this is not a collegial discussion with the law. Some may challenge this, but ultimately the court will variously be interested in complications of analysis introduced by the profession of anthropology, and only variously. It's something for us to note. And in the recent case I wanted to refer to, which is this Central Queensland, previously known as the Adani claim after the proposed coal mine, I think it takes us to some interesting examples of this. Firstly, the decision is excellent to read as to the role of anthropological expertise, because the judge has a useful summary drawing on what's been said in previous decisions about the role of anthropological evidence, including that for Justice Reeves in the Beliondo case, it's not just about opinion, actually, it's including evidence as to the truth of the lay evidence and of primary facts. The anthropologists have been recognised, he says, as producing a record of statements that have been made by research participants, which is very important. Clearly taking genealogies back beyond the memory of living claimants. And he says it's a question of weight rather than admissibility. So this is another example where the legal case says anthropological expertise is definitely admissible. It's a question of what weight to be given to it, and that'll be done on a case-by-case basis. There's a couple of really interesting things that emerged from this case. One was that some of the anthropologists involved read the legislation, the Native Title Act, took the court and the judge and everybody else to the question of what the preamble says, and said that because the preamble foreshadows a beneficial outcome, if you like, that is, the legislation is beneficial in its intentions, this leads them as anthropologists to evaluate probabilities and err towards an opinion which will be beneficial rather than have any other outcome. Clearly, where that kind of judgment has to be made, which is so common in claims and in all the other work I've been talking about. However, the legal decision was that this is not so. So it's important, it seems, for anthropologists to know that the preamble is not applying to the fact-finding role. Experts cannot adopt what the judge calls beneficial or redressive reasoning, because that's the role of the court. So it takes us back to the expectation of independence rather than erring towards an intended beneficial outcome, despite what the facts may say. All kinds of difficulties may arise, given my earlier comments about anthropological practice, I think here, including anthropology's disciplinary focus, which is through the teaching of the discipline to certainly, for want of a better way of saying it, teach and research and understand and address beneficial outcomes for the descendants of colonized peoples across the world. Quickly, a couple of concepts where this was evident in the Beliondo case. So some of the anthropologists took the court to the concept of cultural amnesia, drawing on Basil Sanson's research and others, where anthropologists will be familiar with the fact that it's only 2 to 3 generations remembered in oral traditions, and that there can be this forgetting of what the circumstance was prior to grandparental generations, and that in this case, this one then affected or was said to have led to some ambiguities about tribal identities and about genealogies over time, where the history since sovereignty is much more than 2 to 3 generations. But the court then said, well, this idea of cultural amnesia, you know, is iffy. It's, the judge doesn't like it. Yes, if there are witnesses who are dealing with sensitive matters in their family's histories that may conflict with documentary records, that it's understandable that there'll be some cultural forgetting, if you like. But it wasn't a very favourable reception of the concept, and the point was made that discrete legal assessment will be required for any such piece of evidence that argues about the cultural amnesia that's part of traditional law. And this was even more so with the concept of gratuitous concurrence. Most will probably know that this is a concept developed decades ago, actually, by a linguistic anthropologist in the Spinifex country of WA, as to the evidence in legal settings from Indigenous witnesses and a tendency to agree with propositions put in a gratuitous fashion because of the pressures of the court setting or the legal setting or the inquiry associated with the legal case. And so the anthropologists, some of them in this Valiondo case, sought to explain changes to identity group names over the years, in recent years, because initial decisions were taken gratuitously because of pressures towards unanimity in meetings and the politics of those meetings. Keep in mind, this was a case with big political issues and outcomes given coal mining and so on, and challenges to Indigenous agreements that had been made. So the state's response was, well, does this mean that the truthfulness of the evidence given by the Indigenous parties is going to be fluid depending on circumstances? And the court's decision was to not accept gratuitous concurrence, especially when it has the appearance of trying to excuse or explain away inconsistent data with an anthropological concept. So to go to some summary points, I've tried to talk about the independence of anthropological work. Over the past few years, you know, I've just had countless conversations with colleagues working in the sector who have to try and manage the tension between expectations for independence on the one hand and the sort of the politics of interests across different Indigenous parties and other parties on the other hand. So there are these pressures together with the expectations for independence. The bottom dot point there is that I think it's so important for employer organisations and also clients engaging the services of anthropologists to have this conversation openly as to how there will be support from NTRBs, SPs, land councils, other organisations. If the expectation for the anthropologist is to exercise independent professional judgment, then when that's challenged, if it is challenged, there has to be ways for providing support. Overall, I conclude that, yes, I still definitely encourage this sector as a terrific working career for people. I think many in this conference would agree how stimulating and rewarding it can be. But we do need clarity as to the sorts of tensions that I've tried to address. We do need transparency about how anthropology is understood. And I think we need that among employers, the parties engaging consultants and Indigenous groups. Thank you very much for that. And I'll stop sharing my screen now.